appeal from the Court of Appeal of Barbados, hearing of appeal in CCJ Appeal BBCR number 3 of 2021 between Elliston MacDonald Greaves and the state. The members of this morning's panel are Mr. Justice Witt, presiding judge.
Good morning, Council.
Mr. Justice Anderson.
Good morning, Council.
Madam Justice Rajnath Lee.
Good morning, everyone.
Mr. Justice Barrow.
Good morning, all.
And Mr. Justice Burgess.
Good morning, Council.
May we have the appearances, please? Thank you.
May it please this Honourable Court, Dennis Effie, in association with my learned friends Dave Cumberbatch and Derek Boyce, appearing for the appellate.
Good morning. If it pleases you, Your Honours, Elliston Seal, Deputy DPP. I'm appearing in association with my learned friend, Mr. Oliver Thomas, Senior Crown Counsel.
Yes, thank you very much. Mr. Seal, given the recent constitutional changes, are we now talking about the case of Greaves against the state or still against the Queen?
We refer to all the cases in Barbados now as the state.
Okay. It's just a small thing, but nevertheless, good to know.
Very
Thank
well.
you.
Thank you, Your Honor.
Mr. Hadley, I think it's your turn to speak now.
Yes, sir. Your Honour, this is an appeal stemming from Criminal Appeal number 11 of 2018 from the Barbados Court of Appeal. On the 12th of July 2018, sentence of 24 years imprisonment, less 1/3 for his guilty plea, unless the remand time is imposed on the appellant. It's been an appeal on the ground that it's manifestly excessive. The background, Your Honour, is that on the 3rd of July, before Madam Justice Weeks, the appellant was charged on the 15th of December 2015. He murdered Kellyanne Gill, his common law wife, for some 13 years. The plea to manslaughter was accepted on the grounds of provocation. Let me just briefly outline the circumstances of the case. They had both parties overnighted at a friend's house, and this friend run his house in some sort of a brothel. And having overnighted there on the 22nd of December 2015, the appellant left the premises in the morning of the 23rd. And in that time, a client attended the house where Ms. Gill had sold sex and such like, unknown to the appellant, and the persons could also buy marijuana there as well. Now, once this sex client, was at the property seeking the services of Ms. Gill, the appellant returned to the property. There was an exchange between the client and the appellant, and thereafter with the appellant and the deceased, which culminated on the appellant stabbing her once in the neck with a knife. The sole issue before this Honourable Court is whether the court should exercise its discretion under the Criminal Appeal Act, Chapter 113, allow the appeal of the appellant and impose a lesser sentence than that imposed by the court and sanctioned by the Court of Appeal in Barbados.
Counsel?
Yes, sir.
Just one point of clarification. You mentioned the interchange between, I think you referred to the sex client and the appellant.
Sorry, I referred to
the sex client and applicant and the appellant. There was an interchange between the two.
Sorry, I missed the last part of what you just, your question.
I'm confirming that you indicated there was an exchange between the sex client, as you refer to the person, and the appellant.
Yes.
Okay. And then you said there was an exchange between the appellant and the deceased.
Yes, sir, yes.
Yes. But was there not something else that was interposed between those two exchanges? Did not the owner of the premises also get involved?
Yes, sir, yes. The owner of the premises got involved. I think at 2 points. The first one was to warn the sex client that the appellant had now returned to the premises, and 2, before the culmination of the deceased being stabbed, the house owner had intervened to stop the quarrel, if you like, between the deceased and the appellant. In fact, I think the wording was that he had pulled the appellant away from the deceased.
Thank you.
Thank you. The law that governs whether or not this appeal, in my view, should be successful, I've looked at the Penal Systems Reform Act, sections 35 to 41. I've also looked at the PLO versus the Queen of guidelines there.
Excuse me, may I interrupt you? I assure you I can hear you, but there is a vibration or a resonance which seems to derive from your microphone being too far away from you, and we are picking up the room audio rather more directly, or more of it than we should. I assure you I'm hearing you, so you will not lose anything, but you begin if the microphone will come closer to you.
Chair, could I say perhaps we could all mute, because we're getting so very uncomfortable to hear this morning.
Yes.
Yes, sir.
Yes, Mr. Hadley, you can try again.
Yes. I've looked at other cases too, in addition to the PLO. I've looked at Ricardo Griffiths and the Queen, the Arundel Patmore case, Sumaro Omar Smith, Dwight Ovid Ali, Bevan Murray, Tirith Basad, Walter Prescott, and also the case of Oliver St. Clair Archer. And by looking at these cases, try to gauge the law that emanated from these cases to make an assessment as to whether or not the sentence imposed on the appellant and the laws that were spent in these cases is just in the circumstances. And in my respectful view, the sentence is an unjust sentence based on the circumstances. Your Honor, if I may just go to my submissions.
Mr. Hadley, just to be very clear, the sentence we are talking about, it seems to me that is 16 years, because the deduction for remand has nothing to do with mitigation. That is a calculation, but simply saying time spent on remand is already counted as serving part of the sentence. It would seem to be, in this case, was 16 years. Would you agree with that?
That is the final.
Mr. President, if I may.
Sorry.
Sure.
Yes, I'm sorry, but I don't know if it's my implement, my instrument here, but I'm getting some serious feedback, which is making it very difficult to follow what is being said. I don't know whether it's my computer or whether other persons are experiencing the same difficulty. My brother, I see our sister nodding her head, and I am also mentally nodding my head.
And I'm also having the same problem, Justice Burgess.
It's very
I'm
difficult.
experiencing the same also.
I'm hearing my other colleagues, but Justice Witt, your There's distortion in your speaking.
Okay, well, I'm not sure. I can hear all of you very well.
I'm hearing you very well now.
Okay.
And so am I.
Good. So, Mr. Hadley, the question was, are we not talking about a sentence of 16 years? Because the deduction for time spent on remand is a matter for calculation. It's not a matter of mitigation. So the sentence seems to me for 16 years. If you compare it to the sentences that were mentioned in Lord, because at that time there was no deduction.
I'm sorry, Chair, but I hate to be the fly in the ointment, but the problem has returned. I don't know whether you have near to you another device which is on. It might be causing an issue.
No, I have nothing. I'm nothing else on. So that's.
President, do you think that IT can sort this out? Because it's going to be a very, very hard morning if we go on like this. It's virtually impossible to follow this.
I think the acting registrar wants to make an intervention, Chair.
Yes.
Yes, Justice Witt. I think Mr. Hadley, one, needs to mute when he's speaking. Also, based on what Justice Rajnath said, may we just adjourn for a few to see what's happening? Because we are getting the impression it's from you, Justice Witt. But there's also the feedback from Mr. Hadley. So could we just adjourn for a few and we'll return, please, Judge?
Yeah,
I take it nobody leaves.
Nope, nobody leaves, Judge. Yes.
Okay, but before we do that, maybe if everybody else closes the microphone, let's see how that works. Because Mr. Hadley's phone is now muted, or his microphone. So the question is now, can you hear me clearly now?
Yes, Chair, perfectly.
So it's Mr. Hadley. So Mr. Hadley, when you are not speaking, please mute your microphone, all right?
Well, I would say everybody who's not speaking,
thank you.
Mute and see if we can get there.
Yes, so, thank you, Judge.
Okay.
Perhaps we don't need to adjourn, Registrar.
Not at all, Justice Barrow. Thank you kindly.
Okay, we only do that if it still doesn't work. So yes, So Mr. Hadley, my point was, are we not, when we talk about the sentence in this case, it seems to me that it is 16 years because the deduction for remand has nothing to do with mitigation or anything. It's just a matter of calculation, how much more your client will have to spend. So in fact, it's 16 years, and certainly when you compare it with the Lord sentences, the guidelines, at that point in time, that was before Romeo de Costa Hall, and I thought in those days there was no such thing as a deduction, or at least not a clear deduction for time spent on remand. So in fact, it would seem to me that this is a 16-year sentence, not a 13-year sentence.
Yes, Your Honor. The issue is to do with the starting point of the sentence before certain deductions were made. And also, the issue also is about the uplift in the sentence for the personal aggravating factors of the appellant. Relative to your comment about the time spent in remand being deducted, that's not an issue before the court. The remand time. The issue is the starting point and also the uplift for the personal aggravating factors.
Yes, please continue.
Yes, Your Honor. As it relates to the aggravating factors by which the judge would have used to a starting point of 20 years. the perspective from this side is when you look at the hierarchy of offences and the guideline case of Pierre Lord, which set the guidelines on which sentences of this type for manslaughter should be gauged. The judge says a number of things in relation to how the matter, in my view, ought to have proceeded. And she says at page 179 of the record, lines 15 to 17, in reference to guideline 3, in terms of accepting certain parameters, she says that the guideline is not directly on point. She says that no firearm was used, but there are some mitigating factors suggestive that at guideline 3, the circumstances surrounding this incident was really around guideline 3, even though perhaps a bit of nipping and tucking was needed in order to fit it within the guideline. And then she says further, in reference to guideline 4, at page 179 of the record, lines 22 to 24, she says, and I quote, "Again, the facts of this case do not fall squarely within this category, since in my view, the knife is an intrinsically dangerous weapon." Now, guidelines 1 and 2, as you would be aware, are used in this case where a firearm has been used. So in recognition that this case fell somewhere between guideline 3 and guideline 4, in my view, the sentence following the guidelines should be within that bracket somewhere. Now, if we may look at the guideline 3 in itself, sorry, asking my best. If you may look at the guidelines to do with number 3, for example, it speaks of in a contested trial where there are no mitigating features, and it raises a sentence of between 16 to 20 years in a contested trial. And in that type of case, when there's a guilty plea, the range of sentence, it says, should be between 10 and 14 years. Now, even though it doesn't fit squarely within guideline 3, and the reason it doesn't fit squarely within guideline 3 is because, in terms of that range of sentence, there's some mitigating features there. And because they're mitigating features, respectfully, I can't see how it can possibly start at 20 years. Now, it's been attributed to me by the judge that I stated that the case does not fit within Pierre Lord. And that's not what I said in my plea in mitigation. I stated in my mitigation that this is not a Pierre Lord circumstance. And after I said that, I think it's at page 131, that's the record thing, please. After I stated that it's not a Pierre Lord circumstance, I went on to outline why it's not a Pierre Lord circumstance. And because in my view, the aggravating factors of Pierre Lord were more severe in this matter. But I did not say that it was not within the guidelines, which is a mass difference. And I realize that's something that's going to...
Mr. Hadley, can you mute so I can speak? Yes. Okay, you're saying it doesn't fit in the guideline 3 because there were mitigating circumstances. But I think the judge also said there were also aggravating circumstances. So doesn't that bring you up back to the required level of number 3?
In my view, Your Honor, the fact that in terms of there being a trial and such like, and by the accounts for aggravating circumstances already in number 3, where the sentence is gauged between 16 and 20. But when you factor in the mitigating circumstances, then it must bring it down. Because guideline 3 is in recognition of a case where there's no mitigating circumstances. So in this case, where you find mitigation, it must come down. And the mitigating features prevalent in this case were such things as provocation, such things as the fact that there was no premeditation and such like of the matter, and also that he did not go armed with a knife.
But if if it was not provocation, it wouldn't be manslaughter, would it be? Then we're talking about murder. And same thing with premeditation. So provocation is part of this package, so to speak, because only if there is provocation in what form than ever, there would be manslaughter. So is that something that fits into this schedule? It seems to say, number 3 seems to tell me, okay, if there was no firearm used, but an intrinsically dangerous weapon, like a knife, and there are no mitigating circumstances, then the range is 16 to 20, and an early plea of guilty is 10 to 14. Now, here are mitigating circumstances, but there are, says the judge, but you will come back to that, also aggravating circumstances. So doesn't that make it fit more or less in this category 3, if we would be only looking at these guidelines then?
Your Honor, the only aggravating circumstance that I was able to see in this matter was the fact, and this is an aggravation to the offence itself, was the fact that a knife was used. I'm aware that my learned friend on the other side may have something else to say, but the only aggravation I found was the fact that a knife had been used. There was issues found by the judge in relation to domestic violence, and that was also the basis on which the starting point was gauged at 20 years. But in my respectful view, there's no domestic violence history to this matter. And I say that in light of the character witnesses that came, especially Quentin Greaves, who gave certain evidence, where he outlined in his testimony that he had witnessed the deceased being aggressive and violent towards the appellant, and the appellant had responded. And other things were said to him. My learned friend on the other side spoke about a video. There's no evidence, there's no video rightfully before the court to which a judge should take account. That would be based on the record, that'd be hearsay evidence. There's no authenticity as it relates to the video before the court. And again, certain things would have been said by that character witness that makes it quite far-fetched to find an issue of domestic violence on the part of the appellant. In addition to that, and I've outlined in my submissions, that the issue must be about a history of domestic violence from the appellant towards the deceased. But based on the character witness, based on the probation report, none of them can point a history of domestic violence towards the appellant.
Counsel, if I may, I follow what you're saying. And I understand you to be saying that there is a difficulty in your view in fitting the sentencing exercise conducted in this case within the Pierre Lord guidelines. But isn't your problem much deeper than that? Because I gather the argument on the other side is that the Pierre guidelines themselves are not applicable. And the other side bases that argument, in part at least, on decisions of this court, and primarily the decision of this court in Terus Prasad. So in convincing us of your approach, would you not need to deal with the argument that the Pierre Lord guidelines do not apply? And there are decisions of this court, I mentioned one, but there are others as well, which have made very clear the view of this court that the Pierre guidelines are in urgent, I think we have said in some cases, need of reform, and that they're not consistent with the approach to sentencing, which this court has adopted and represented in its decisions.
My respectful view, Your Honor, the Pierre guidelines is what we had to work with at the time. And they've now been adjusted by the Court of Appeal in this particular case. But in my view, at the time, we had that to work with. In terms of the inadequacy, in terms of the expression of this court in the Terus Prasad case.
Sorry, what time was that?
Sorry.
What time was that?
What time was?
You said that you had to work with the peer load guidelines at the time. So I'm asking you, at what time were you working with the peer load guidelines as opposed to what was said by this court?
That was 2018. What was said by this court, I understand, is 2018, I believe. The guidelines date back to around 2000, I believe, 7. But I think, too, that this court had made a suggestion that in spite of the need that perhaps there ought to be some sort of reform, it was for the authorities in Barbados to bring forth those changes and not for yourselves to deal with them. So even though in Melbourne things said, by the way, in my respective view, the authorities in Barbados still had to make that adjustment for the court in Barbados. And it's something that you decline to do yourselves.
But this court did give certain very express guidance on how the guidelines could be developed. I agree with you that we said we would not ourselves do that. It was really the province of the courts in Barbados. But did we not give certain guidelines? Did we not make certain comments on how the guidelines could be developed? And certainly, Justice of Appeal Narayan, in his judgment, seems to have thought that the peer guidelines were incompatible with the approach that this court had given in its judgments.
Your Honor, but the problem necessarily may come if you have what I call an anomaly where some, in some courts are still paying adherence to the guidelines and some are not. And whilst the guidelines are in vogue, necessarily it's still incumbent on judges in this country to pay adherence to them. So if you have necessarily some judges in some cases deviating from peer law and looking at the new framework that you have set in Tira Prasad, and then others obviously looking at the old framework in peer law. But at that time, the law in Barbados was
under the rules of precedent counsel, is it that individual judges at the first instance level have a free choice as to which approach they will take?
Sorry, Your Honor.
Under the rules of precedent and the rules governing how first instance decisions are to be made and what higher authorities they're bound by, I'm asking you whether it is a free option on the part of first instance judges in Barbados as to what framework they are going to be governed by.
The answer is simplistically no, Your Honor. But that being said, certain parameters still had to be stuck by. And what I'd say too is this, is that the peer law necessarily was not set in stone as it relates to certain things. And at the end of that judgment, I think a judge would have certain latitude if the circumstances fit, depending on the circumstances, to step outside the bounds. But where you have a circumstance where necessarily it fitted within that framework, then in my respectful view, it should be adhered to, in spite of the comments made, because the framework necessarily gave a lot of latitude, or the new framework, shall I say. But in my view, the framework of peer law, necessarily if the circumstances presented, could be stepped out of, if there's special set of facts or circumstances. But this case is no different from a lot of the others that have gone before, under which certain sentences have been adhered to.
Thank you, Counsel.
Mr. Hadley, are you saying that, because you were saying, well, this sentencing took place before Prasad, are you saying that if new guidelines come out that lead to higher sentences, that could not be used for cases that were dealt with before those new guidelines came out? Is that what you are saying too?
You're talking about retrospectively punishing someone for. In my view, I don't think the person ought to be punished retrospectively for a law that was in place at the time, and necessarily that attention should be paid to.
Yes, so you're saying
in terms of the new guidelines now, should something happen now and the judge needs to utilize guidelines, new guidelines would be adhered to. The comments were made, yes, in Passat, but at the same time, the old PN law was still in operation in this country as it relates to the guidelines.
So you're saying the new guidelines, whatever they are, if they lead to higher sentences, should not be applied retroactively?
In terms of guidelines, Your Honor, in my view, there was no new guidelines in relation to sentencing. There was something that was said in relation to an approach, but the guidelines differ fundamentally from something like PLO, which in my view is more rigid from what was said in the court in Tirith Passat.
Sorry, counsel. Am I being heard? Sorry.
Yes,
I can hear you.
Sorry. No, I'm sorry about that. Now, am I right in understanding you to say that the courts are bound by the ratio of cases, but not by dicta, because you're talking about things said, by the way? Is that what your answer is to my brother, Justice Anderson?
If something is said, by the way, in my respectful view, it's not binding, Your Honor. And it's not only in relation to this matter. It's not only about the necessarily the approach, is the framework that had been used as it relates to matters that the judge would have taken on board in arriving at that sentence in the first place. And I gave the example earlier of the domestic abuse issue in order to arrive at the 20-year mark. And another factor that would have been used to, one of the mitigating factors, the fact that the appellant was not armed with a knife. And that's something, too, in her judgment, that was not taken account of. And that's a serious aggravating factor that would have led to the objective seriousness of the offence and led to a higher starting point. So remember, whichever framework you...
But Mr. Headley, sorry, I thought that much consideration was given in Tirith Passat to what was said about Pierre Lord. When there's such a considered opinion, isn't the courts in Barbados well advised to follow the indications from the Caribbean Court of Justice as a matter of precedent? Should they treat that as highly persuasive, almost binding?
In my view, Your Honor, it would be persuasive, but I wouldn't go as far as to say it's almost binding. And I don't do away from the fact necessary that a judge may follow it. But in my view, I don't see it as being binding because the suggestion was made to the court and the decision was left to the Court of Appeal to change the law here as they deem fit. So in my view, it was persuasive.
Thank you.
I was just making the point, Your Honor, in relation to the aggravating factors and what would have led to a higher sentence than otherwise. And I use the domestic violence, for example, and also the issue of going armed with a weapon. And certainly no credit had been given to the appellant in the unfolding of the circumstances, with him taking a knife from the kitchen, which was close by, and then using that in order to commit the offense. And in my view, that's a serious aggravating factor that he was not given credit for, the fact of his not being armed in advance. And it was an unfolding of circumstances there and then at a moment in time.
You mean a mitigating factor, I suppose?
Mitigation, yes, mitigating factor, but the fact that it wasn't acknowledged by the judge would have enhanced the objective seriousness of the offence. As a consequence, would have led to a higher starting point of the sentence of the appellant. And what I'm suggesting too, in terms of the judge's comments in relation to Guideline 3 and Guideline 4, is highly suggestive based on the comments made, even though it didn't fit squarely within that framework. Seemingly, there was a wholesale deviation from those guidelines to warrant a higher sentence in this case. So in my respectful view, there are no special or exceptional facts of this matter that warranted such a high starting point. Your Honour, as it relates to the mitigating factors, I've mentioned the issue of domestic abuse already, to suggest that there was no proper evidence before the court as it relates to the appellant being an abuser in that case. And I've outlined too, I've outlined in the submissions the report of the probation officer. When in the report, the probation officer, it's quite detailed according to him, quite meticulous in his work, and he cannot say in that report that the appellant had any history of abusing the deceased. What he says is that there was a history of domestic abuse in the matter. So there's a history of domestic abuse. It doesn't say where it came from. But later on, a character witness, Quentin Greaves, highlights where the deceased, he had witnessed the deceased abusing the appellant. So it's quite far-fetched to suggest, as my learned friend on the other side did, and as the judge concluded, that indeed the appellant was an abuser. And it's quite detailed in terms of the exchange in the submissions between my learned friend on the other side, the assistant DPP, and that particular witness, and which culminated in that witness saying, well, I wasn't present. Yes, and if indeed the judge was to conclude, based on video, that was indeed hearsay evidence, because in fact that witness did not see anything as it relates to the video, but indeed he witnessed an exchange with them before, when they were going to a wedding, and the deceased was not invited, and the deceased would have attacked the appellant in his presence. Another point, Your Honour, according to the judgment at page 181, lines 25 to further on page 182, where it's been stated that there's an aggravating factor that the appellant, or there was an intervention, shall I say, by the house owner where the incident happened, and it wasn't heeded. And I think we have to be very, very careful where there's an issue of provocation. And in my view, there's any attempt to water down the issue of provocation and necessarily resulting in a higher starting point or an aggravating factor in the matter. And I say that relative to the comments of my learned friend in his outline of facts in relation to the case. And if I may just turn to it on a particular page, but basically he says that the reason provocation had been accepted is because of the unfolding of the incident and where the incident finally happened and the kitchen where he got the knife were very close by. And he goes on to say is that we can't even say there was a cooling off period, which suggests that everything unfolded in one swoop, in spite of the intervention. And if later on the judge is going to say that intervention was made, which was not heeded, in my respect with you, that's not a fair position as it relates to the appellant. And necessarily that's a watering down of the provocation issue. It's all got to be done. In this case, to justify for want of a better phraseology, a higher starting point. And in the case of Suzerain, again in the bundle, it, in my view, frowns on anything said which may lead to a watering down of the issues at hand, in this case, provocation. And it suggests that proper sentencing cannot be done where comments are made which water down, in this case, the issue of provocation. And my suggestion very strongly is that stating that intervention was made, which was not heeded, cuts away or chips away at the element of provocation, and there can't be a framework for a proper sentencing on that issue.
Mr. Again, would you not agree that there are levels of provocation? For example, in this case, I assume the provocation was that he was confronted with this situation and he got into a rage and acted in that rage. There are other situations where the provocation comes down to almost self-defense, but it was not proportionate and so forth, and so there are different degrees of provocation which could be measured in terms of sentencing. What would you say to that?
Well, necessarily there could be different measures of provocation. But what I'd say in relation to a case like this, there was provocation at the point of the incident. And my learned friend would have made quite a lot of it in terms of the technical and non-technical provocation. But in a case like this, there seem to be both types that are present. There's this provocation at the incident itself, and there's provocation to the statement of the appellant given to the police, where when questioned about why did this happen, and he said, I was tired of her quarreling and shit. That was his response. And later on, again, the character witness, Quentin Greaves, gave evidence that when sometimes the appellant was by him doing work, the deceased would turn up and she'd quarrel. And I think quarrel and fret is the term he used. So necessarily, there's two different types, obviously. The build-up, which the appellant spoke of in terms of the reason it would have been done for quarreling and shit, and you have the more instantaneous provocation of what happened at the incident itself. And I think we have to be very, very careful in an instantaneous reaction to something, even though there's immediate intervention, if there's not a cooling off period, to start making comments as it relates to intervention was not heeded. There's a very, very dangerous, I think, comment to make. And in my view, as I said before, it chips away at the issue of provocation.
Okay, in the interest of time, could we go to some other elements that you think are important for us to consider?
Your Honor. Again, in terms of mitigating factors, it was stated by the judge that the appellant did not threaten, sort of deceased did not threaten the appellant and such like, and that seems to be a basis on which sentence would have been given to. And the issue of threats and such like was never an issue in this. So it appears that irrelevant considerations have been made by the judge in her sentencing of the appellant in the matter. I'd mentioned before, which is a high mitigating factor, the issue of not traveling with a weapon. He wasn't armed in advance or anything like that, and no credit had been given for this issue by the judge. The personal mitigating factors as it relates to the appellant, the sentence would have been uplifted from 20 years to 24 years as a starting point and such like. And the appellant's criminal history had been used along with the fact that he used cannabis and cocaine and such like. And also the fact that he was poor. That's one of the measures that's been used to assess whether or not someone presents a risk to the society. So he was assessed as being high level, medium to high level of reoffending. Respectfully, Your Honor, but when you look at his history, the fact that for 24 years he had not committed any crime, not been found guilty of any crime, 24 years. When you look at the antecedents, two that were considered by the court to uplift the sentence from 20 to 24 years, in my view, that's a rejection of the ideals of individualized sentencing. And that's under Section 41 of the Penal System Reform Act. It speaks of, and the case of Griffith in this country speaks of the same thing. If there's similar offences, for example, if he had been violent before, then necessarily that's a consideration that can be used by the court in order to protect the public. In a case like this, where you're enhancing the sentence by uplifting it, that's in contravention of the principles of individualized sentencing. And in my view, it ought not to be done in terms of the case law that leads on that issue, and also in relation to the statute, the Penal System Reform Act, which also deals with that. That's another issue.
Sadly, the probation officer said that he used what he calls the Service Inventory Revised Risk Assessment Tool. Any idea what that is?
Your Honor, I don't have a clue, and I hope perhaps you can enlighten me. But what I'd say is this, you see, in terms of using a broad brush to cover all aspects, and this is something that was a pains to deal with in the courtroom itself. You know, because someone comes from a poor background, because someone smokes weed, I don't know what it does to you. I don't know if it causes you to be overly excited or relaxes you, but necessarily, it doesn't make you into some sort of criminal raving madman. In this case, the circumstances, in this case, neither are exceptional. And what I mean by that, he doesn't have a history of violence.
Counsel, sorry, Mr. Headley, if I may, I thought that what my brother president was pointing you to is that the assessment was a scientific assessment. The evidence before the court was as to the chances of repeating the crime, a crime, was based on a scientific evaluation. We may not know how to operate the scientific evaluation, but certainly the probation officer was acting or giving advice based on scientific information, a scientific methodology, wasn't she?
Your Honor, if that is the case, and I have a couple of views in relation to that, then necessarily, based on his history, based on his 24 years of not offending, and I say that, even when we look at the antecedents, he'd stolen $50, $20, and such like. The using of the report, or the conclusion of the report as it relates to the risk factors, and adding certain weight to it, in my view, is unjustified, because he hadn't committed any crimes in some 24 years. And to turn around and then say, well, the fact that, according to this scientific thing, your chances of committing an offense is greater than the other person, perhaps, yes? But in light of the fact that he hadn't committed any of the 24 years, I think it's highly unreasonable then to use that as a tool to enhance the sentence, in this case by an additional 4 years.
Counsel, I think that you're insisting that you don't have a methodology superior to the one which was actually used, and that you are not proposing that another one should be used. That's pure impressionism, isn't it?
You're right. If I had such methodologies, perhaps I wouldn't be sitting here right now speaking with you. No, I don't have an alternative. what I'd say too in relation to that, and I saw it as a matter of double counting. So in terms of the outcome, which is the determinant factor, he's a medium to high risk of offending. And the reason for that is because, let's say he smokes drugs, yes? And at the same time, not only is the assessment, the end product, a medium to high risk being used against him, if you like, as an aggravating factor, as a personal aggravating factor, but what's being used to come to that assessment, again, too, is being used as an aggravating factor. In this case, it was mentioned by the judge that the two things being used against him, one, he smokes drugs, so that's an aggravating factor, as well as the end product, which is because he smokes drugs, he's a medium to high risk of reoffending. And it might be that's a double counting too, of the aggravating factors being listed against him.
Mr. Headley,
which again,
yeah, can I ask this as you're speaking? If the counsel for the defense is not happy with the probation officer's report, you think that there is something in there which prejudices your client or is wrong, is there in Barbados the facility to call the probation officer for questioning? And if so, was that contemplated? I may have missed it or done in this case. I may have missed it altogether.
When you say, is there a facility I could contact him and speak about it? I'm not aware of one.
Oh, I mean, in the court before the judge, so that the judge is made aware of issues that counsel for the defense feels that is important that the judge should hear more about, take into account, not take into account, just as you have been speaking.
I think that he was actually cross-examined by both sides before the judge. Isn't that so?
Yes.
Yes, Ron, yes.
So in that case, there is that facility. And then in that case, all of that is brought out then, Mr. Headley? Was all of that brought out as to his risk?
It was brought out. It was in the report as well as it was questioned during cross-examination.
Yes.
And I would have...
Yes, and I wanted to know, is it then that the judge has made up her mind that this having taken place, she's satisfied that the probation officer has come to the decision which he can come to based on the tools that he utilizes?
Yes, she's come to that conclusion, yes, and utilized it, much to my objection, because in my view, in the pre-sentence report, there were many factors in there, positives as it relates to the appellant, that more weight ought to have been paid to. And I say that in light of the content, the full content of the pre-sentence report, as to what a wonderful person he has been. The drug taking aside, these are comments that's been made aside from the fact that he smoked drugs and aside from the fact that he's seen as high risk and such like, but throughout his community, family and such like, he's seen as a very, very good person. He's been referred to as being a gentleman and such like. He's not caused any problems in his community. And everything else pretty much that went in the pre-sentence report, in my view, the judge has paid too much weight to the fact of the risk factor in spite of him not committing any offences for 24 years, and the ones that he committed prior to that was when he was a young man, 18, 20 and such like. And occasionally, in my view...
Yeah, thank you, Mr. Headley. That is interesting and important. What does the Court of Appeals say about the approach of the trial judge on the probation officer's report? And what was made of that for the Court of Appeal?
The Court of Appeal, to my recollection, did not say a great deal in terms of the judge's assessment as it relates to the weight she'd put on the pre-sentence report. even though I had outlined, in my view, that there was all good things stemming from the report, aside from one or two factors, i.e. the drug taking, and the final assessment as to the risk factors. But other than that, there was throughout the report very, very positive things coming from friends, family members, wider members of the community, including his former employers as well. I think one of the character witnesses said about him is that if there's 100 properties in his community that work was done on, he had done 99 of them. So the point I'm making is that fundamentally, in my view, my word is, in my view, based on the circumstances of the case, I think he's been hammered. That's my perspective on it. Because of all the good things.
Mr. Hadley, we did not get that report. Huh? It's not part of the record, I think.
I apologize, Your Honor. Sorry.
And there was, as I understand it, there was also a victim impact statement, because of course he and the deceased had 6 or 7 children, and well, mother is dead, father is in prison. These things are usually also of some relevance when you look at the whole situation. We didn't get that.
I apologize, Your Honor, because in my record it was appended at the back of the court record. So that's on my part. I have to apologize. It was appended at the back of my court record that I have in my possession. But what I'd say is that there are all positives in this report in relation to the appellant, not just now, but throughout his life, pointing out what a wonderful father he's been and such like. And one of the things being said in the report too is that this particular incident was out of character.
It would be nice if we could read that for ourselves.
I apologize. I can undertake, Your Honor, to get this report to you in swift order, because I accept the importance of it.
Okay.
Mr. Hadley, in addition to the that pre-sentencing report, there's also, just as with President mentioned, the victim impact statement. Is there any other document that was before the sentencing judge which is relevant to our deliberations this morning?
There's no victim impact statement. What would have happened is that the officer, the probation officer, I believe, would have interviewed the family members, and detailed in the report would have been the effect on the family in that report itself, not something separate and distinct.
Thank you. So in one report, then, there's everything that was before the judge.
Oh, yes.
Yes, thank you. Thank you.
And these matters were also considered by the Court of Appeal, I take it, these reports.
They would have been in front of the Court of Appeal.
They would have been in front of the Court of Appeal. Okay.
Whether or not they were considered, that's a question I'm not certain I can answer.
Yes, I understand you. Thank you for that. But I assume you're making the point that you don't expect us to sit as a first instance judge to reevaluate those kinds of reports. You're not asking us to do that, are you?
In terms of as a first instance, if for example, and the point I'm making is that in terms of the weight factor, when you look at all the circumstances surrounding this matter, if it is that, in terms of my argument, necessarily not enough weight may have been paid to, in this case, a report such as this. And in this case, if not enough weight has been paid to it, or it's not been weighed properly, in terms of the fuller circumstances, in my view, you can make that adjustment.
Right, I understand you. I wanted to just ask you a couple other things. How much longer does your client have in prison? When is the release date?
He was sentenced in 2000 Caribbean dollars. Release date, Your Honor, just Caribbean dollars. So he was sentenced in 2018. And 16 years from that time would be now about another 13 years or so. Give or take.
Do you take into account any time he had spent previously on remand?
Yes, that was deducted, Your Honor. That was deducted. He's been on remand since 2001. Remand first. Since 2015, he's been incarcerated December, and it's now 2021, so December again. So 6 years now he's been on remand. Well, been incarcerated.
Okay. I must say that for my part, I was sensitive to the point that your client expressed remorse and apologize, particularly to the family. I think that's an important element. So I just wanted to balance off those two questions in terms of how much longer he has to serve under the current sentence against the fact that he showed obvious sensitivity to the dysfunction and the disruption that his action would have had on the family. So I think that's interesting. My sister had pointed my attention to a couple of paragraphs from the judgment of Narayan J.A. in the Court of Appeal. And I know your time is coming to an end. And before it expires, I wanted to just get your view on the guidelines that the Justice of Appeal had enunciated in his judgment. And he evidently thought that those guidelines were consistent with what this court had said in a number of cases, including particularly Taras Prasad. I just wanted to get your view as an experienced criminal lawyer in Barbados, without prejudice perhaps to what you have said earlier this morning, just to get your view on what the judge said in relation to those guidelines. Do you have a view that you care to express to us on those guidelines?
In relation to the guidelines, Your Honor, based on, I think, certain circumstances of a case, necessarily, there's some cases that higher sentences ought to be imposed, and I see that the guidelines does that, yes, but respectfully, it depends too on the circumstances, but necessarily you need a framework. So if the case demands it, necessarily to go higher up. And there's some cases where, respectfully, that should be done. But I think, and I looked at this very carefully, when there's the issue of in this case, like provocation, and certain assumptions are supposed to be given, in this case, in the appellant's favor. Yes, I gauge that on a particular circumstance, yes? And you're saying, really, that in this case, he lost control, yes? And number two, the loss of control was reasonable in circumstances that would have caused him to react the way he did. And in the next breath, in this case, I believe necessarily a sentence of 24 years is warranted. That doesn't, in my view, respect the issue of provocation, one, and the effect or impact it may have on an appellant such as this. And there need to be certain parameters. Yes, in some cases, you can go and say, put a higher sentence, but in terms of recognizing certain factors in the case, in this case, provocation, the sentence is not warranted in light of certain circumstances such as this. And I looked at, and again, it's covered in Sutra, the English cases and the range of sentences where provocation is found in a domestic setting, and the recognition of the assumptions being made in favor of the appellant. And the range of sentence there was, I think, between 5 and 8 years or so, the average, and in some cases 3. And the complete extreme, maybe a suspended sentence. And recognizing certain things. And in my view, if the principles are the same, in this case, we recognize that you lost control, and we recognize that your loss of control was reasonable in the circumstances. And I think we have to be very, very careful in terms of accepting those assumptions and in the next breath giving high sentences, irrespective as to the circumstances that may unfold in these type of cases.
Yes, well, thank you for that. I wanted perhaps a more generalized response to the various ranges that the judge indicated that he thought would be consistent with what we had said in our case. And also, to be fair to the judge, he did say that obviously these are just guidelines and individual cases might require some degree of departure. But as an experienced criminal lawyer, I just wanted to get your view on what he had said. Well, thank you very much, Counsel. Thank you.
Okay, Mr. Hadley, I think you are over your time already. Is there something important that you want to say in conclusion?
In conclusion, Your Honor, I looked at the framework, the decision given in the case of Sumaris Smith, the judgment of Justice Warren, and in recognition that this type of case didn't fit squarely within guidelines 3 and 4. A bit of nipping and tucking was done in order to arrive at a sentence. And in that case, in my view, there were more aggravating factors because of the amount of injuries that were caused to the deceased. And in this case, one stab wound compared to Sumaris Smith, which is 5, is a mitigating factor. You do compare the two. But in terms of wording in that case, of acknowledging it doesn't fit squarely within Guideline 4, nor does it fit squarely within Guideline 3, suggested that, in fairness, in terms of consistency of sentencing in this type of case, that necessarily the 10-12-year framework based on that case would be appropriate, but in this case less, based on one stab wound or one injury as opposed to multiple in Sumaris Smith. That would be my conclusion, respectfully, Your Honor. And in my view, based on the whole of this matter, the decision should be made to reduce the matter, because in my view, again, holistically, the sentence is excessive.
Thank you very much, Mr. Hadley. I think we can now turn to Mr. Seal for the state.
Good morning, Your Honors.
Before you start, I have to come back to it again. So, because when we look at the Lord guidelines and also the guidelines now presented in this, or a suggestion for guidelines presented in this judgment by the Court of Appeal, the number of years that are mentioned are actually the number of years without the deduction for time spent on remand, isn't it? I think at some point you made that point that the Lord guidelines are from a period before, Persaud and also before Romeo da Costa Hall. But I gather that the number of years that are mentioned in these guidelines are, let's say in this case, it was actually 16 years that was imposed, deducting then the time spent on remand. But we have to look at, when we look at these guidelines, we look at the sentence without the deduction for time spent on remand, because that differs in every case. Is that a correct assumption?
That is my understanding also, Your Honor. That's my understanding.
And a second point before you start, because we have to look at this particular case, but of course we are also looking at the broader picture of guidelines, etc. And it would seem to me, and you could react on that or not, but it would seem to me that now that we have a new situation where murders can even now be sentenced with life or less, that when you come to a final picture of the sentencing in, let's say, in homicides, including murders and manslaughter, that you need to have a holistic picture when you decide on a final scheme of guidelines. But anyway, that's just a thought that occurred to me, and if you wish, you can go into that. But of course, let's focus on the issue of the case itself. But if you want to deal with that too, then you're welcome, as far as I'm concerned.
As Your Honor pleases. First of all, I hope to be relatively short, and I will say first of all that the respondent rests on the submissions that we gave as far as the written submissions were concerned. And with your leave, I would just wish to respond to some of the things stated by my learned friend, Mr. Headley. I need not rehash all the facts. The court is well seized, I believe, of all those and all the submissions. So I propose to deal primarily with what was said this morning by my learned friend. My friend indicated that, first of all, there was the only provocative, aggravating factor, he said, was the use of a knife. And obviously, we strongly disagreed with that. Aggravating factors included a number of other things, but clearly something that was said by the court, mentioned by this court, was the intervention, and my friends sought to make light of an intervention. There must be a rule or room for a peacemaker, a person who seeks to quell things, notwithstanding a person may be heated. And that role was a very important role that man sought to do before he got away from his grasp and still went to the kitchen and dealt that fatal stab. My friend said it was only one stab, but a stab in the neck, one fatal stab, that must be something that one must look at. He seems to emphasize a lot on the character of the witness and says that the character witnesses said that this man was almost a saint. He said there was no domestic violence. And what made it appealing to me that he sought to bring this character witness, which the record speaks of. And my friend has this character witness, Greaves, as a person who is a witness, first of all, of the truth. And although the veracity of his evidence came into question when he was cross-examined, because he said at page 94 of the record, when asked about incidents of domestic violence, he said he only knew of one incident when he, meaning the appellant, was going to a wedding and she didn't get invited, meaning the deceased didn't get invited, and she ripped off his shirt. And when he was cross-examined, so you don't know anything about them, otherwise he only knew about this incident. When the video was put to him about him beating her unmercifully with a piece of wood, all of a sudden he knew about the details. It was a bank holiday. It was at the bottom of my gap. And from what I heard, she attacked him first. Now, character witnesses, although we do give credence to them, the question is how much weight we can put to them. They're coming on the behalf of the appellant. They're coming on the behalf of the accused man or the now convicted man. I don't think you will bring witnesses who wouldn't do less than sing your praises when they come on your behalf. But if the court now examines him, the court has to determine what weight should we put on his testimony. He comes and he says he didn't know, but when the video is put to him, all of a sudden she started it, but he didn't see the video. And obviously he adds, they didn't put the part when she was beating him. So all of a sudden he knows about this video that existed. So when my friend says that we can't look at the video or give any credence to the video or any weight because it was hearsay, that can't be true, because he himself knows of the video, and in any event, generally...
Help me here, counsel, help me here.
Yes, please.
The objection is taken that a person cannot speak to hearsay material with any authenticity, and no weight should be given to what the person says in relation to hearsay material. And you are saying that we should reject that proposition? Is that what you're saying?
No. I'm not saying that. I'm not saying that, Mr. Justice. I am just saying that generally witnesses of this nature, these character witnesses, generally speak about things they hear, things that they believe, because they are...
Stop. If that is what generally takes place, then it may be that it ought not generally to take place, or when it is what generally takes place, then in any instance where it is a generalized piece of information, then the weight given to that generalized piece of information. And I loved an expression that you use. The witness said in relation to the video that what he heard was so on and so on. I mean, that really stirs a former criminal law practitioner, doesn't it?
Of course. I understand what the court is saying. I'm understanding the court correctly. But when we talk...
Mr. Seals, yeah, of course, the judge clearly based the sentence partly on the fact that there was an abusive relationship, and this was the culmination of that relationship. Now, you ask, apparently these witnesses were not so sure about that, but could you just very succinctly say what was the evidence that there was such an abusive relationship?
Well, the evidence of the orals by him himself, if we look at part of it, the testimony, when his statement, when we were speaking of in the facts at page 19, when he was questioned by the police officer after giving the statement that he did. And these are pieces of evidence that I'm asking the court to look at. When he was asked about the reason why he stabbed the deceased, he said, "I was tired of her quarreling and shit." There was and the evidence of the probation officer who did the pre-sentencing report. He did indicate that there was evidence of, though rejected by my learned friend, that there was evidence of domestic abuse. And I think that from these instances and these pieces of evidence before the court was of the view that there were instances of domestic violence in this relationship. Verbal confrontations and physical confrontations. And that was the report by the probation officer, Mr. Owen Birch. My friend indicates that he did not speak of who was on whose behalf the violence came from, but I think that one can infer from the report what he is saying to the court. And I think that also my concern was that if my friend felt that this witness was before the court, and if my friend felt that there was that the probation officer was not clear enough, he had the opportunity to ask him about who the violence was meted out against. He was present in the court. And that is why I also add at this juncture, now I remembered it, when he spoke about the service inventory revised risk assessment tool. If he didn't know the tool or felt it was not the proper tool to be used, he had the opportunity also at that stage to ask what it was about, how it worked, and deal with it, because the witness was before the court. But to wait now at this stage and then ask this court to deal with it and say that it was an unfair assessment because he felt in his own right that this man was a good man and he was hammered, as he said, then he had an opportunity to ask about this tool. And if at all possible, he had an opportunity to refute it if he could bring another person to say, or another expert, because I assume that we treat the probation officer as an expert witness to refute the evidence. But he couldn't simply say, my friend simply couldn't say, because he felt that there was more there were more factors in favor of a better report than the one the probation officer gave, that it wasn't a report that should not have been accepted.
Counsel, may I respectfully suggest to you,
yes, please,
that I think as criminal law practitioners, you will know that when you want something to not be given any particular weight, you do not dwell or delve into it. You treat it as what is stated, and you save your powder for your submissions in relation to how that evidence to be treated. If he were to call some other person who would establish that the alleged scientific basis had credibility, then would he be helping his client? Is it not better in a criminal trial to say nothing and decide afterwards, I will snipe at that, because we do not know what makes this probation officer an expert in scientifically assessed determination as to character, probability of future offending, etc. And as he's doing now, saying, but hold on, this is what this probation officer says upon one, as he's alleging, pseudoscientific basis, when we have 24 years history to say that he has never done any of the things which would make him hereafter a danger to society. I'm just raising with you the way how criminal law is practiced.
Respectfully, Your Honor, I think that there's a difference between criminal law practice and tactics in trial. And at this stage, when one is trying to find, one is looking for all useful information to assist in the sentencing process. The judge, this person has already pleaded guilty. So I don't think there's any need for tactics. This person has already pleaded guilty. The judge asked for a pre-sentencing report to assist the court. This is when all cards, I believe, are thrown at the table, on the table. I don't believe that this is time to play the games that we practitioners.
If I may interrupt you and shorten this exchange, I respectfully, as a criminal law practitioner, not agree with your course, but it's a matter for you. So continue with your submissions.
As you continue, Mr. Seal, could you let us know just very briefly on this, whether there's anything else in the record which will assist us in assessing the weight that had been placed on the probation officer's report or the pre-sentencing report, and as far as the assessment of risk concerned? Is there anything else?
No, Your Honor. I can answer that in one question. The risk assessment is that left for the probation officer, and I think the court operates on that basis, unless there is something that I think comes before the court that is clearly in conflict with that. I think the court depended primarily on that risk assessment.
Thank you.
Mr. Seal, isn't that required under the Penal Reform Act?
Certainly, that is the reason that it is almost mandatory that report be requested, because I think the court can't just outside of its own step out of its own what shall I say, perimeters to deal with issues of that nature, and for that reason to assist the court in sentencing that is required in all instances.
Thank you.
Thank you. Added to that, if I may go a little further and to comment on something that my friend says, and I think it was a question from Your Honor, Mr. Justice Burgess, when my friend was asked the question about the Tiraf Passad and the utterances of this court as it relates to reviewing sentencing guidelines in other cases. He indicated that the most it could be was persuasive. He didn't come over to admit that it was binding. And I was of the view, and we humbly submit that utterances from this esteemed court, even arbiter, must be something that we have to take credence of. There's no doubt that, and I think we all know cases where things said by the way, arbiter dicta became very, very important and was binding from then. If we look at the case, although that is not a criminal law case, Central London Property Trust and High Trees House, the dicta of Lord Denning as it related to promissory estoppel became enshrined all over, although that was mere dicta. And I think that when we look at the utterances of this court, even more than once, Burton and Nurse, and the same Tiraf Passad, that it really was of the view that the sentencing guidelines needed to be revised. What my friend and most of my criminal law defense friends have held on to is that they love the old dispensation of Pierre Lord, but they want the new deductions as it relates to the court's direction, where it has gone in Passad, where it has gone in Nurse. But the two are not mutually exclusive. I think, sorry, they are, because you can't bind the two together, because you can't have the old way of sentencing when a judge would give a sentence at the end of a trial. I remember, I don't have the longest history as counsel at the bar, but in my years, I have started out my practice when we came, and at the end of the day, when the man is convicted, I have been in court and the judge sentenced on that day, even before you didn't have probation reports and all these things, and the sentence was on that day. Sometimes the judge would say, I've considered how long you were in prison. There was no mathematical deduction, anything. He just did that and the sentence was given. Over the years, we have evolved into something much better than that, with all the deductions and all the understandings of pre-sentencing and giving the lawyers at the bar rights to make submissions. I mean, submissions were not even something when I first came. And this is only a few years. I'm talking about how this change took place, just under 20 years. We didn't even make submissions on sentencing. Nowadays, all these things are done. So I do not understand how we can want the old dispensation, because it sets years, and these were years at the end of all the deductions. Because if we look at Pierre Lord, the times placed there is the final, my understanding, is those times placed in the Pierre Lord is the final time you should get, full stop. After a guilty plea, this, that, and these are the times you get. But we want to stick slavishly with it because it favors us. And still we want the new deductions, because then it will deduct from even the times that we have under the Pierre Lord. So it would even create a lesser sentence for individuals. I don't think you can benefit without, we've learned that you can't take the benefit, you have to take the benefits and the burdens. So if you want to stick in the old regime, which certainly cannot work now, with what this honorable court and have insisted that we do when we address sentencing, looking at the aggravating and the mitigating features of the offense and the offender, and all of these things coming together. The two cannot work. But if we continue in this vein, this is what will happen. We are getting the final sentences out of Pierre Lord, but now we're getting all the 1/3 deduction, exactly how much time a person has spent in prison, and all of these. And it certainly cannot say much for a society where when we look at persons who believe and rely on the criminal justice system and fairness. It is not only about retribution. I can understand that. Certainly you don't want people to languish in prison forever, but the crime must fit, the punishment must fit the crime. And if a person has committed a crime of this nature, because when we're talking about the finality of murder, death, that is the issue. Although persons may say, as my friends say, it is out of character. I would have hoped that murder is out of character of any individual who comes before the court. I don't think you can get a habitual murder, you can get a habitual thief, you can get all these things, but murder must be generally, although we've heard of serial killers, but murder must be out of character of everyone. So although we
This was not a murder case, counsel.
Please, sir?
This was not a murder case.
Sorry, death, homicide, I'm sorry, the killing of an individual, the unlawful killing. And added to that, I'm glad that you said that, Your Honor. Added to that, again, is how we evolve even now. Because rightfully thinking, with the non-capital murder now that we have before us, and the capital murder, I'm thinking that instructions, I would want to say the word instructions, because I went to court on that day, obviously, as I do with instructions from the DPP at that time. Instructions would be different because because of the disparity, so to speak, in sentence when a person pleaded guilty to, you couldn't plead guilty to murder. Offenses of this nature, where a person left, notwithstanding he was tired of the shit, as he said, and got a knife and stabbed somebody to death, even with that issue or provocation, one would have to stand before a jury to determine whether or not this was not a case of murder. But in those days, clearly because of the wide disparity of sentences, because sentence of murder certainly was death then, one was more inclined to accept pleas of manslaughter, even in these borderline cases. Because when we look at this, I still believe that although the plea was accepted, and I have to admit I accepted it myself on instructions, it was a borderline matter. Because even if we look at what we say we may call infidelity, the appellant himself did not even use that as his reasoning for killing the lady in this matter.
Sorry.
No, please, my brother, go ahead.
Counsel, what the appellant said, we know objectively what took place. So it is not that he just upped and decided, I am tired of this shit and today is the day I'm going to kill you. It is that there was this very inflaming incident. That is what drove him to his excess. Now, it may be that there was a build-up. It may be even on your thesis that there was a history of abuse, etc. It may be that they fought every month or whatever. But what took place in this case is not that he killed her because he was tired of the shit. He killed her because he got into a rage and would not be contained by the intervention of which you spoke and so on. But let us not simplify or oversimplify the proposition. He got into a rage. In some societies, it is accepted that infidelity is major provocation, etc. And therefore, I think we have to accept that he did not kill her out of tiredness of the shit.
Respectfully, sir, I accept the court's position, as I always do. But he was interviewed in relation still to this matter. He spoke in relation to I think when we look at it, it is very clear what he said, and I cannot enter a man's mind. He has to, and I don't think he was a fool. When put to him, and with your leave, I just wanted to say, I know you probably have read it over and over again, but I have read it too over and over again, and I can't put thoughts in his head. He was asked, do you know the man who was in the bedroom? He said, no. Do you know if Kellyanne was involved with him? He said, I ain't sure. He said, did you stab her because of him? He said, no. Why did you stab her? That's when he said that. So I'm saying, notwithstanding, we are fully aware of the circumstances surrounding this death, that we cannot, he was the person who had to speak, and I don't think he was under any pressure for his utterances. And I don't think that ordinarily we can put words in the mouth of an appellant or any person if they indicate otherwise. Yes, the circumstances were very, very clear to the bystander, but to him, we still do not know what ticked him off, because
with the greatest respect, Counsel, we know what ticked him off, and you just said it. There is a proposition in law that the state of a man's mind is as clear as the state of his digestion. I think you will recall that. We know what ticked him off. Now, what he said, what weight we give to it is a different matter altogether.
Oh,
so
very well.
What was his mental state at the time when he gave this interview, etc., is a different matter. But I mean, clearly, that may inform the view we take of what he did. So it may be, as I said, that the history is what made his rage in this case increase to the point of homicide. It may be, but we cannot pretend that he did it because of the history purely. Come.
Respectfully, sir, I hope the court didn't think I'm pretending. I was just making a submission, but I too am fully aware of all the aspects of the matter. I am seized of it, so I'm not trivializing it. But I'm only going, as I said, as the record has stated.
Mr. Seal, I think, shall we move on to the next point?
Of course, sir. That's why I said I'm going to be brief anyway. Anyway, my friend relied heavily on the case of Shamara Smith, which he said is most closely related to, other than the other case of Arundel Padmore, which has the upper end sentence. And I think we can clearly distinguish these two matters. Shamara Smith was a matter where the appellant felt that he was poisoned. He was under fear of death. He said the lady gave him something to drink. He thought he was dying, and he put out his rage on her as a dying man, expecting to die. Notwithstanding, he didn't, but it was his thinking at the time that he was poisoned by this lady. Even in that case, so although there were about 6 stab wounds inflicted, which differs from this matter where there was only a single stab wound, the facts and circumstances are, in my humble opinion, significantly different. There was no third party also there to intervene in the fracas. So I don't think that is a case well suited in these circumstances where we can apply the sentencing guidelines of that. And again, we are talking about a case, obviously, also that predates this court's utterances as far as the sentencing guidelines and the ineffectiveness of the sentencing guidelines of Pierre Lord. So I don't think we could use that in circumstances where we have new dispensations and new guidance as it relates to the final sentencing and things that must be taken into consideration when we address our minds to sentencing now in matters of homicide. That is my humble submission. So unless the court really wants to hear anything further from me specifically,
yes.
Sorry.
Yes, on two matters, and I raised them with opposing counsel. The first is, do you know, when all other things being equal, and of course, sometimes things are not equal, when the release date will be for Mr. Greaves? Do you know that?
I am not aware of the date. All I can do is say that if having been sentenced to 16 years, in 20, after the deduction, he ended up with 13 years from 2017 up until present. The mathematical deductions are straightforward, other than the times that the prison will give off for good behavior, which is 1/4 of every year. 1/4 of the total sentence once there's good behavior and industry. That is what the Prison Act says. As long as there's good behavior and industry, a person will be entitled to 1/4 of his sentence off. So that would be a further deduction of about 4+ years.
So what? Give me a ballpark figure then. What year is it? I thought of 2028, but I'm not sure.
Just a moment.
I'm looking at it, my brother, I'm also thinking it may be around 2027.
2027.
Yeah, if it's a fourth of the time.
Yes.
Okay.
Once the fourth is on the 13.
Yeah.
Yes, the fourth is on the 13.
Right.
Thank you.
Notwithstanding any sentence, sorry.
I'm sorry, please finish.
No, I was just saying, it is always there. Once the court gives that sentence and there's no problems in prison, he will definitely get. In fact, at one time I was told that even when you get a bit of a problem, unless it reaches the threshold that the prison chief feels otherwise, everybody basically will get that discount.
I was told the same thing, and maybe from the same source. Okay, the second question has to do with what Naranja has said in the Court of Appeal about guidelines that he thought would be appropriate. And of course, those guidelines go far beyond this case. And as coming from the DPP's office, I just wanted to get your view on those guidelines and whether you care to make a comment on them.
Yes, sir. Our understanding at the DPPs is basically is that the guidelines are a huge improvement on the guidelines that existed before. There's no great emphasis on firearms because Pierre Lord, the first two guidelines were primarily focused on the use of firearms, and we understand that death can be caused in many ways and suffering can cause in many ways, and the firearm is not the only implement that will cause death. In fact, strange enough, as we would know, the firearm can cause death instantaneously, as opposed to a man beaten to death by a piece of wood or strangled, which will cause death in another fashion with more suffering. So we were glad that the guidelines did not focus primarily on firearms, but talk about the circumstances of death and the great exceptional brutality and depravity. So we were satisfied with. Sorry, sir.
Steele, if I may, I know the question is Mr. Justice Anderson's, but I just wanted to piggyback a little because you are making reference to the fact that the Pierre Lord guidelines emphasize or place a certain emphasis on the use of firearms.
Yes, sir.
What I'm wondering is whether Sir David, in formulating those guidelines, had in mind the particular kind of danger that was posed in Barbados society by the wanton use of firearms, and whether any guidelines by the court, certainly not this court, by whoever, should not be there as an indication to would-be users of firearms that they will be treated as in a special way. Is there any room for that? I don't have a view. I'm just recognizing that Sir David would not have identified firearms unless he thought that it had a special implication for criminal justice in Barbados. So I'm innocent. I don't understand what the question I'm raising with you, but it's just that I wonder what your thoughts on that is. And I apologize to Mr. Justice Anderson, but I thought I'd intervene to raise that question with you.
My thoughts on it, Your Honor, my thoughts on it is that understanding the dynamics of society, and I think the courts sometimes respond to what is going on in society. Right now, again, we are faced with an upsurge of firearm offenses. But my view is that when we focus primarily on firearms, then when the odd case, or not the odd case, when cases come up without the use of firearms, but it's just as brutal, then lawyers, as they do, focus on, look, this guideline speaks about firearms. My client he wasn't using a firearm. But as it is now, I think it is widely thrown open that then a judge can use his or her discretion to bring firearms into these, it depends on which level or which of the guidelines it fall under, and make a particular emphasis on the use of firearms and speak about the aggravating factors because of the use of firearms. So to me, I believe it gives the judge more wiggle room to deal with other offenses rather than making it so exclusive that as soon as my client does not have a firearm, then he has to fall lower down when the case was one of exceptional brutality or something of that nature. I think to pigeonhole is more difficult, to make wider and give the judges a greater discretion. That's how I would answer it. I don't know if it adequately speaks to what we're saying.
Thank you very much. Thank you. That's helpful.
Yeah,
Thank you.
Yeah, to see if the matter were to be decided under these guidelines that the Court of Appeal issued at paragraph 71, which guideline do you think would be relevant, and what starting point would be applicable?
I am of the opinion that the bottom of guideline 2 would be applicable. 15 years would be
15 to 25, is it?
15 to 25 years would be applicable. So, and I just want to add one thing outside of that, is that when we look at the guidelines as they are now, I have heard in the courts now that guideline 3, and I've heard this from defense counsel, is somewhat vague. And I don't know if we can put some body to it. But my view is that when we look at guideline 3, it says for offenses of manslaughter where the aggravating circumstances of the offense outweigh the mitigating circumstances, the starting point should be 10 to 15. And the question is, I would have to look at it that when we look at 3, we are saying cases falling outside of 1 and 2, then we would have to use 3. But I have had counsel on the other side, even with the use of these new guidelines, saying, well, 3 kind of vague.
I think, sorry to interrupt you, counsel, but I think with that caveat or gloss that you put on it, it makes sense, doesn't it?
Yes, that's how I view it. But exactly.
Sorry, counsel. I'd said to you that yes, I was satisfied with your answer. But as I think a little bit more, wasn't there? Didn't Parliament at some point in time attempt to separate out possession of guns and gun crime with a minimum with a minimum mandatory sentence. Didn't Parliament itself differentiate between one type of weapons and another type of weapon?
That's true, but I think that, and I think that Parliament, I should say, found itself in trouble with the court, because then having set minimum mandatories, then the court was of the view that it breached the separation of powers doctrine.
Yes,
and basically.
Yes, sorry, I agree with you on that. But what the question I'm raising with you isn't there in Barbadian society a thinking that gun crimes are a special kind of, in a special category? That's the question I'm raising with you. I know that Parliament ran into, I think I was in the court at that point in time.
Exactly.
So I remember well, but I'm just wondering aloud. I'm trying to think through.
Okay.
Yes.
So I understand that society abhors the use of firearms. Parliament does. Most right-thinking people do think the same way. But my answer to that is basically what I've said before, that the judge can use these things as clearly aggravating factors which will push you up, as opposed to having it in the guidelines which exclude then people who are not firearm carriers but causes the death of an individual by some other means. So I think it is better to include than to exclude. I may be wrong, but that's just my view on it.
No, I think your view, if I may say so, appears to be supported by Guideline 4, because in Guideline 4 is where there's no firearm. So obviously, the use of the firearm can be seen as an aggravating circumstance in Guideline 1, Guideline 2, and Guideline 3. I was also intrigued by 4, because you always need to think of the sort of extreme case. And what is sometimes put forward as an extreme case is, for example, a case of euthanasia. You know, where somebody takes the life of another person because the other person's in serious pain, and they've been asking this person to assist them in ending their lives and so on. Assuming that it's a case of manslaughter, I wondered, well, how would that treat with these guidelines? How would the guidelines treat with it? Now, if you were to, I presume that a case that is, speaking just in general terms, would come under Guideline 4.
I have that opinion also, because, well, euthanasia generally loosely called mercy killing.
Yes.
One would be looking at the intention of the individual to put this person out of the excruciating pain and suffering. So I think that person, and this person also would be in danger of death also. So it isn't that you're killing a healthy person. This is a person who most probably is dying terminally, and you're assisting them. It is no right to do that, but clearly I would assume so it would still fall at a lesser end.
Thank you, Counsel. So if you then started at, let us say, 5 years, you are going to then give a discount of a third, assuming the person pleads, guilty, shows remorse, and so on. Where does that take you? That takes you down to what, 3 years something? There could be other mitigating factors. The point I'm trying to reach at is, do you still want to put this person in prison for a year or 2, even though they have acted in the way that they have to relieve the pain of somebody else? And that is what I'm trying to struggle with, whether 4 should start at 5 years.
Oh, with all the deductions, that's
because even when you include all the deductions, you're still going to send this person away, it seems, starting at 5, for a significant period of time, maybe 2 years or 3 years or something like that.
Clearly, Mr. Justice, that's when we have one vision, and when we have sometimes 4 or 5 heads of intelligent people looking at it. I may be looking at it with only my view and not even recognizing that. Certainly I didn't until you put it to me. I think that we should, that's why when we envisage all the cases and the extreme cases, this may happen without our looking at it, and then we fall into the same problem and you look at the rules as inadequate. That is the reason why we need this apex court to have a view, have a look at these. I wasn't strictly asking for a ratification of these as they are. I was honestly hoping, and that was my reason for asking this court to review these with from your esteemed position to determine how effective they are, and make whatever adjustments can be made to these guidelines. But at least for sure, the courts have departed from the old Pierre Lord. I think that is an improvement. But I think when this honorable court looks at it, clearly your deliberation and your experience and thinking can bring a new look to these, or even a revision of these, because they're certainly not set in stone. That is why we're asking this court to bring
that judgment was a unanimous judgment by the Court of Appeal. Am I right?
Yes, it was.
Yeah, it was. Yeah. Thank you, Counsel.
Yes, Mr. Seal, I really do think that it is a little more complicated than cannot be solved with a few guidelines. It's a start, but that's all it is. Now, you were saying, for example, this particular case would be in the lower ranks of number 2 of these new guidelines. That would be 15 years. And then you would have to deduct 1/3 for an early plea. He had remorse, and this is a case where you could give the full 1/3, so that you get to 10 years. So that you get, and then you still have to deduct the time spent on remand. So you get out when you use number 2 in this case. It would seem that you get a result which is much lower than we have now before us. So, as we have said in the Passot case, actually, it's not a matter of mathematics. It goes far beyond that. So, really, I think we can say a few things, and we might do that about these suggestions, but it can only be the start of a much broader discussion, which, as we have said, really needs to be done in Barbados itself, with all the practitioners and those involved in this at hand. But we can see what we can do with it.
I may have misheard, Counsel, but did you say that you were suggesting that in this case before us this morning, you would start at 15? I didn't understand.
I think I misspoke, actually, because when I was I was looking at the 16 years that were given in the case, in this same case, and that was before the deduction. I think I was still bound, but still sitting in the old what should I say, Pierre Lord, when I looked at that merely as a final sentence before the deduction of time spent. So I think I ended up speaking outside of my turn. But I was really talking about this same, that is why I was endorsing really the 16 years, saying it could have been 15, but saying that this could have been the 16 years. But I think, and I must admit, I erred in speaking about it even before all the deductions was made. So I wasn't looking at it that way. I'm sorry.
I think when the question was raised, the issue was, well, what range do you think would be the starting point? And the range would be number 2.
Definitely.
And then it is, of course, a matter of judicial decision making as to where within that range the starting point would be.
That's correct.
And I understand the judge to have taken a starting point of 20. And therefore the question is whether she was wrong in doing that.
I do not believe she was wrong. I wholly endorse the judge's approach to sentencing and the guidelines, although that she used, because she recognized it was outside the guidelines. I exercised her discretion, and I was of the view that, and we humbly submit that was appropriate in the circumstances.
Thank you.
Okay, now I have one more question about this. Because we have said, okay, in this case, actually, the sentence was 16 years. You deduct time spent on remand. The remission part, how is it calculated? Is it 1/4 quarter of 16 years or 1/4 of what has left, what is left now, 13 years and something? Could you?
It is 1/4 of what is left. Do you have the prison rules? 1/4. Yes, 1/4 of what the prison rules basically say that once a person is in prison for more than 30 days, he is entitled to 1/4 in remission. Yeah. Once he is of good conduct and industry.
Sure. So it's 1/4 of what is left, the 13
what remains.
Something. Yeah.
That's what remains.
Okay, that just for clarity's sake. Thank you.
Oh.
Is there anything else?
Nothing from me.
Okay, thank you. Mr. Hadley, replying?
Just very briefly, Your Honor. On the point of clarity, as it relates to the Sumaro Smith case, where 10 years had been imposed, there was intervention in that case by someone pulling off the appellant there as well. So there's similarities in the circumstance in relation to Sumaro Smith as in relation to this particular case on that issue. But it's just a point of clarity, because my learned friend had said something different. And the second point, in relation to a question that was not directed at me, but directed at my learned friend, in relation to the new guidelines, which guideline would this case now fall under? And I listened to my learned friend and also looked at the guidelines, yes? And I looked at guideline 4 for offensive manslaughter, where there's strong mitigating circumstances of the offence, for example, the absence of premeditation, which is the case here. No use of a firearm or other offences weapon. It goes on to say the presence of serious provocative words and so on. So provocation is there. The only issue then necessarily would be the use of a knife. So in my view, and it's one for consideration, there's strong mitigating features of this case, not aggravating features, there's strong mitigating features. So necessarily, if the use of a knife is going to take it from the realm of guideline 4, which is the next guideline would it be taken into? And in my respectful view, it would more come under guideline 3, because there are other mitigating factors to consider, such as the fact that the appellant did not go armed with a knife. That too must be considered as a mitigating feature. Additional to that would also be the absence of, let's say, the domestic violence, which my learned friend couldn't point out to this court, aside from what we've already discussed. Definitively, where is the domestic violence in the system previously? And that obviously was a consideration that was taken on board by the judge in the sentencing of the appellant here. The absence of violence throughout his history and such like. All these are strong mitigating factors that can be taken on board to put it within guideline 4. But necessarily, if it is that you're going to say a knife is an intrinsically dangerous weapon, then arguably it shouldn't possibly take it to number 2. It should really take it to number 3. And that's a point, obviously, for consideration by the court, but there are many, many, many mitigating features which would bring it down, but the aggravating feature, and the only one that I can see in this matter of a knife, may necessarily take it back up to number 3. And that's the extent of my response to my learned friend.
Okay, thank you. We will consider the case, and as soon as we come to a conclusion, we will let you know to deliver a judgment. So thank you very much. I think I can wish everybody happy holidays. And I suppose somewhere in the beginning of next year, we will see a judgment. You will see the judgment, and it will be delivered. You will be notified.
Thank you. Likewise to you and your honors. Have a blessed Christmas.
Grateful to the court, Your Honors.
Thank you.
Very happy returns. Thank you.
And Madam Acting Registrar, could you please close the session?
Judge, I thought you did. You did such a wonderful job. I didn't want to do it again. But thank you, Mr. Justice Witt. Thank you, Mr. Justice Anderson. Thank you, Madam Justice Roger-Lee. Thank you, Mr. Justice Barrow. And thank you, Mr. Justice Burgess. Thank you, Counsel. And thank you to the staff of the Caribbean Court of Justice. Best wishes for the season. And we look forward to seeing you all in 2022. This court now stands adjourned. Good day to all.
Thank you.